My Lords, I was on the verge of taking you to another international authority on the principle of effectiveness. This is the WTO appellate body decision in Korea Definitive Safeguard Measures, tab 51 of the bundle. May not need to take it up, but I'll quote the relevant section for you. It's at page 3038, paragraphs 80 to 81. This is what the WTO appellate body said. The principles of interpretation of treaties set forth in Articles 31 and 32 of the Vienna Convention on the Law of Treaties apply to the interpretation of the provisions of the WTO agreement. We've also recognized on several occasions the principle of effectiveness in the interpretation of treaties, which requires that a treaty interpreter must give meaning and an effect to all the terms of the treaty. An interpreter is not free to adopt a reading that would result in reducing whole clauses or paragraphs of a treaty to redundancy or inutility. In light of the interpretive principle of effectiveness, it is the duty of any treaty interpreter to read all applicable provisions of the treaty in a way that gives meaning to all of them harmoniously. An important corollary of this principle is that the treaty should be interpreted as a whole, and in particular, its sections and parts should be read as a whole. Now, with those words of wisdom in mind, let's go to the judgment below, and this is at tab 11 of the core bundle.
Could you give us paragraphs, please?
Page 155 of the bundle.
Could you give us paragraphs, please?
Of course. Perhaps we can go to paragraph 119. We're starting with Lord Justice Stuart's judgment. Prior to this point in the judgment, he undertakes an analysis of the various cases relating to interpreting international rules, and this is his summary at paragraph 119. He says, a number of strands emerge from these authorities. Roman numeral 1. First, there is no general rule that a national court shall never determine a question of interpretation of an unincorporated international treaty. Of course, with that first statement, we agree entirely. Roman numeral 2, that said, a national court should be cautious about trespassing into the separate plane and legal system of international law, where it has no authority to decide questions of interpretation, and where its intervention may be positively unhelpful for the mechanisms that are in place for resolving disputes, whether by seeking to achieve consensus in the international sphere or by reference to disputes to another court or forum. Now, my lords, that statement relates to the question of justiciability. Of course, justiciability in this case has been conceded. So then we move to the next point. Little Roman 3. The approach to interpretation is that mandated by the Vienna Convention. And again, we agree entirely. But then we go to the next point, and this is where we're starting to get into difficulty. It says this, the court should adjust its approach by reference to where in the spectrum from the broad and largely political or aspirational, or statements of high principle, to the rigidly precise and prescriptive the provisions in question lie. Now, my lords, the difficulty is that what is just stated there is in complete contradiction with the mandatory approach under the Vienna Convention. The Vienna Convention does not contemplate any sort of adjustment based upon a subjective view of how hard-edged or soft-edged the treaty provisions are in the particular circumstances.
I don't really understand that. I mean, that's not it's not a relevant, not a point about the Vienna Convention. It's a point about the wording of the treaty itself. What it's saying is you've got a treaty which is largely political or aspirational. It may not actually result in hard-edged obligations under the interpretive provisions of the Vienna Convention that he has accepted as being mandated in the previous sentence.
My lord, that is exactly the point. And what the premise of your question is that you have to go to the Vienna Convention, you have to interpret the provisions in accordance with the Vienna Convention.
He said that.
He said that, but he doesn't do it. And that's the very point. You have to make an interpretation of the treaty to decide on the tenability view, whether that view is sufficiently close to that interpretation to remain tenable. But you have to interpret the treaty. And the only way you do that is in relation to the Vienna, in accordance with the Vienna Convention principles. And in our submission, the rest of Lord Justice Stuart-Smith's judgment testifies to this contradiction because, as I say, he does not provide an interpretation of the Paris Agreement. Now, our position is that once an international legal question is found to be justiciable, then the court cannot invoke these factors to decline to answer the legal question in accordance with the mandatory approach set out in the Vienna Convention. Because, my lords, to do so is to reintroduce justiciability factors through the back door.
Just pausing for a second, it may be that I'm a little behind the curve of this argument, but you're submitting, are you, that in order to ascertain whether a particular interpretation was tenable, the court has to undertake the task first of ascertaining what the meaning of the treaty actually is to establish a spectrum of tenability. Is that what you're really submitting?
My lord, that's precisely correct, except that we would say, in the first instance, that you should not approach questions of treaty interpretation on the basis of tenability review, because that is to reintroduce justiciability arguments into the proper approach.
Right, so the court has to establish what, in its view, is the correct interpretation of the treaty provision.
In our submission, that's the only way you can come to a view as to whether a particular view advanced by the government is sufficiently close to the correct view to remain tenable. But our primary submission is that you don't get to tenability at all. If it's justiciable, you have to resolve it as a question of law, and that involves coming to the correct answer.
So, as a question of law, what does Article 2.1c of the Paris Agreement mean? That can only be one answer, you say. What is the one answer?
The one answer is the answer given by Mr. Justice Thornton, and my colleague will, of course, address you on those matters in some detail. I'm just leading you out of the darkness.
Just take us to the sentence in her judgment which gives the definitive answer to what Article 2.1c means.
It is provided at paragraph 268. As I say, Ms. Seaman will provide you more extensive submissions on exactly how to interpret the Paris Agreement in accordance with the Vienna Convention. But that is the conclusion that she reaches after applying Article 31, and that's the conclusion that we invite you to adopt. Now, to return to Lord Justice Stuart-Smith's judgment, paragraph 120, and this is at page 155 of the bundle. So he's set out the principles that he says follows from the authorities. And he says this: applying these principles to the defendant's understanding of the provisions of the Paris Agreement, I'm in no doubt that the tenable view approach is appropriate for a number of related reasons. Now, my lords, the difficulty here is that the judge is taking the defendant's subjective understanding of the Paris Agreement that they presented to the court, and on the basis of that understanding, he says that it would not be appropriate to interpret the Paris Agreement according to the Vienna Convention rules. And you'll see the statement where he declines to do so at paragraph 230. And I'll go back to that passage in a moment. So the result is that the executive is able to dictate whether the court will provide any meaningful review of its decision, said to be expressly compatible with the UK's treaty obligations. Here the respondents, of course, said that the Paris Agreement is aspirational and political, and that its provisions are not hard-edged and contradictory. And Lord Justice Stuart-Smith accepted that characterization, paragraphs 121 and 122, and as a result, no independent judicial interpretation of the Paris Agreement was considered to be necessary. Now, my lords, this begs the question, of how the respondents were able to determine that the decision to finance the project was compatible with the Paris Agreement in the first place. How were the respondents able to come to that definitive legal conclusion, given their position in the litigation below and before this court, that the Paris Agreement is vague, soft-edged, aspirational, contradictory, and therefore not susceptible to a judicial interpretation? There is a contradiction there, because presumably when a minister has made a decision that he represents as compatible with the UK's international obligations, presumably that's taken on the basis of legal advice. And if the legal advice is, well, you can't make sense of this, then one would assume that the minister would not make a decision based on an affirmative conclusion that it is compatible with the United Kingdom's international obligation. Now, to contrast this approach, as I said, Mrs. Justice Thornton did apply Article 31 of the Vienna Convention. You'll see this at paragraph 262, page 197 of the bundle. And she comes to a definitive conclusion, paragraph 268. Now, if the tenability standard was really being applied here, what one would then expect is an analysis as to whether the government's interpretation was close enough to the judge's interpretation of the true meaning of the Paris Agreement obligations to be tenable. But of course, there isn't any analysis because, in actual fact, the judge applied a correctness standard. But the two judgments provide us with an illustration of the inevitable incoherency that accompanies the tenability standard. Because either its application results in judicial abdication, so no independent interpretation of the international obligation, or the court applies the correctness standard anyway because it's nonsensical, once an independent interpretation is given by the court, to measure the acceptable deviation from that interpretation for a different view to remain tenable.
Well, that logically removes tenability, doesn't it, on your approach?
Entirely, my lord.
The tenability is a completely false concept in all this.
That is our submission.
Yeah, it does resolve to that.
There
is simply no place for tenability.
There's no place for tenability. There are certain factors that are being deployed in relation to tenability that may be relevant to determining whether the issue is justiciable in the first place. But once an issue is justiciable, you have to decide it as a question of law. Taking the effective interpretation point, returning to the judgment of Lord Justice Stuart-Smith below, I say at the outset, obviously if you're not providing an interpretation in accordance with the Vienna Convention, you're not going to apply an effective interpretation. And the relevant passages of Lord Justice Stuart-Smith's judgment, paragraphs 225 to 231, and this is page 187 of the bundle. And I just want to read a few passages to provide a flavour of an approach that we say, with respect, can be fairly described as the opposite of an effective interpretation. Paragraph 225, Romans 6, says this: the three examples contained in Article 21a to c are global aspirations and illustrations of how the agreement aims to strengthen the global response to the threat of climate change. Formulation of quasi-contractual obligations arising out of the examples is not straightforward, not least because, for example, holding the increase in the global average temperature requires an effort of global will going well beyond the capabilities of any one country party. Now, my lords, with respect, the starting point is wrong. Treaties create binding legal obligations and must be interpreted as such. If states wanted to record global non-binding aspirations, then they could have published a communique, a joint declaration, or something else at the end of the international conference. Instead, they signed a binding treaty that at the time was hailed as a major breakthrough. And the idea that the obligations in Article 2 have no obligatory force for any one state because only the collective action of states will be able to hold the global temperature increase, obviously runs counter to the very object and purpose of the Paris Agreement, which is to demand that each state make a substantial contribution and not free ride on the efforts of others. Paragraph 227 starts the paragraph saying this: there are, to my mind, a number of difficulties that emerge from Article 2.1c as soon as one attempts to generate hard-edged legal obligations from its somewhat opaque language. It's not clear what is meant by a pathway towards low greenhouse gas emissions, what is meant by towards, or by low GHG emissions. Equally, it's not clear what is meant by a pathway towards climate resilient development. Now again, my lords, if the terms of the treaty are not clear, then meaning has to be given to them in good faith by looking at the context for those terms and the object and purpose of the treaty. That is what Article 31 of the Vienna Convention mandates. It's not permissible to pose those questions and then not answer them to justify an abdication from the duty to interpret the treaty. That would not constitute a good faith interpretation of the treaty. Again, another example at 228 says, Friend of the Earth's case is rather different, and is that a low emissions pathway is one that enables the temperature of 1.5 degrees Celsius and well below 2 degrees to be met. I do not understand what that means in practice in circumstances where the world is so far off meeting those targets that no country's reductions could or would enable the temperature goals to be met. Now, my lords, that's tantamount to saying that the objectives of the Paris Agreement are now futile, so states should no longer be held to their obligations under the treaty. And again, we would say that's not giving an effective interpretation to those obligations. But the ultimate failure to give an effective interpretation is the refusal to interpret it properly. And at paragraph 230, over the page, at the end of that paragraph, you see the following statement: accordingly, I do not attempt or purport to give a definitive interpretation of the provisions of the Paris Agreement to which we have been referred, or their legal effect. My lords, I'm going to move to the fifth and final proposition, which is that it's not permissible to convert a justiciable legal question into a garden variety relevant consideration that can only be challenged on the basis of rationality. Now, that's the purpose behind the respondents' insistence on a tenability standard. And they say so expressly at paragraph 19 of their skeleton. That's at page 72 of the core bundle. Now, the principal authority they rely upon is the Corner House research case, and I want to go to that in some detail. It's at tab 16 of the authorities bundle. And my lords, it's actually the only appellate decision that talks about tenability. It was a challenge to the decision of the director of the Serious Fraud Office to terminate an investigation into alleged corruption by BAE Systems in respect of an arms contract between the British government and the Saudi government. And this decision followed a specific threat from the Saudi authorities to terminate counter-terrorism cooperation with the United Kingdom, among other things. And the principal challenge to the decision was that the director had surrendered his discretionary powers to a third party by giving in to that threat. And that ground was rejected by the House of Lords. And in making his decision, the director had stated that he believed that the decision was consistent with Article 5 of the OECD Convention on Combating Bribery of Foreign Public Officials, which was an unincorporated treaty. But crucially, my lords, and this is what distinguishes this case, crucially, the minister or the secretary had stated that whether or not his decision was consistent with Article 5, he would have taken the same decision anyway. That is, to discontinue the investigation. And the House of Lords was unanimous that this circumstance made a challenge based on misdirection of law non-justiciable. To put it another way, there wasn't a domestic foothold in light of that evidence to interpret an unincorporated treaty obligation. So this case, if it is about anything, is about justiciability, and justiciability alone. Can we start with Lord Bingham's judgment at page 787 of the bundle. And you can see, he says it's unnecessary and undesirable to resolve these problematic questions, which is the Article 5 question, for two reasons. And the second one is the director has given unequivocal evidence that he would undoubtedly have made the same decision.
787.
787 of the bundle.
787 what?
Paragraph 47.
Yep.
So the director has given unequivocal evidence that he would undoubtedly have made the same decision even if he had believed, which he did not, that it was incompatible with Article 5 of the Convention. I'm just going down the page. Lord Hoffman agrees with Lord Bingham. Lord Roger says at paragraph 51, first sentence, in particular, I'm satisfied that, as he deposed in his affidavit, the director would have made the same decision even if he had believed that it was incompatible with Article 5 of the OECD Convention. And the final sentence, in these circumstances, it is unnecessary, even supposing that it would be competent for the House to interpret Article 5. Same for Baroness Hale, paragraph 56. As to whether the safety of British lives on British streets is prohibited consideration under Article 5, we do not need to express a view. And skip a few lines, but the director has made it clear that he would have reached the same conclusion in any event, and as a matter of domestic law, he was entitled to do so. Now, Lord Brown agrees with Lord Bingham, but then goes on to consider Article 5 in more detail, and I'll return to that in just a moment. But two things follow from this, my lords. The first thing is that the present case is fundamentally different because there's no evidence that the ministers would have approved the financing of the project if they had reached the conclusion that it was not compatible with the Paris Agreement. So in other words, we're in the Launder-Kebeline line of authority, which says that if you make a positive representation that the decision is compatible with a treaty obligation, even if it's not incorporated, then it can give rise to review on the basis of error of law. The second point to make about Corner House research is that anything said about the House of Lords in respect of interpreting an unincorporated treaty, firstly, was strictly obiter, and it was in the context of justiciability. And this is the great confusion in this case and others. They've taken what Lord Brown said about justiciability in Corner House research, and they've applied it to the standard of review once the issue is found to be justiciable. And again, in our submission, if a question of law, international law, is found to be justiciable, then it has to be treated as a question of law, like any other question of law.
You say justiciability is admitted. Can you just give me the paragraph of the skeleton that says that?
My lord, I was not involved in the case below, but I understand it was a concession made on day 2 of the hearing at page 72 of the transcript, which I regret to say is not within the bundles. But if the court is interested in that exchange, of course we can pass it up in due course.
Concession
that is justiciable.
What is justice?
The question of the compatibility, the review of the compatibility of the government's decision that the finance of the project was compatible with the Paris Agreement.
perhaps I can assist. Justiciability has never been contested by
Sorry,
the
justiciability.
Justiciability has
Yeah.
never been contested by the respondents, and in the hearing below, that question was raised to Sir James Eady, who responded that no, justiciability was not contested.
Well, Sir James, I'm sure you don't want to be drawn on this, but is this a contentious point or not?
My lord, it isn't. We take our stand on tenability.
Thank you.
I'm grateful for that clarification. So could we go to Lord Brown's judgment then in Corner House Research? And again, I preface these remarks by saying, in a sense, this is all beside the point, because we're not concerned with justiciability.
Well, it may be obiter, might not be beside the point.
Well, it's obiter, but it's also obiter on something that we're not concerned with. We're not concerned with justiciability. And as I say, the confusion has been to take what he says about justiciability and then seek to dilute the standard of review by justifying tenability. But that's not what Lord Brown was concerned with. So at paragraph 62, this is page 791 of the bundle.
Did they all agree with Lord Brown later? I mean, earlier.
I've just taken you to what they agreed and didn't agree on, that they did not consider it was even necessary to assess the Article 5 question. If I
Well,
could.
so the answer to my question is Lord Roger agreed with Lord Brown.
I think Lord Roger agreed with Lords Bingham and Brown.
Yes, correct. I'm sorry, I'm just trying to find out how many people agreed with Lord Brown as to whether at least it's the majority of the court.
But my lord, in the separate reasons, that obviously rather succinct reasons that they give, they all say we don't need to consider Article 5. So I'm not sure that could be taken as support for Lord Brown's judgment on what he says about Article 5. Because they say that we don't need to
seem to
consider
have
it.
agreed with him. So it appears to me anyway, but you'll correct me if I'm wrong when I get back to it, that Lord Hoffman didn't agree with him, Lord Roger did agree with him, and Baroness Hale didn't. So he only had one supporter expressly.
My lord, you may well be right. The only caveat I put on it is that at paragraph 51, Lord Roger expressly says that it's unnecessary for the court to go to Article 5 and look at that question at all. So, Lord Brown at paragraph 62 approves of the Launder and Kebeline authority. So it doesn't say anything against that authority. So that remains good law.
Sorry, where's that?
At paragraph 62. And then at paragraph 63 says, why then should the court hear? So we're not in the Launder-Kebeline situation, we're in a different situation. Why then should the court hear not accede to the respondent's invitation to construe Article 5, and if it accepts the respondent's contended for construction, quash the director's decision and require it to be redetermined? Of course, this is the language of justiciability. An invitation to construe, not how one should construe it, an invitation to construe. And you can see how tentative what follows really is, because at paragraph 64, he says this: there is not, to my mind, any one simple answer to this question, although I'm perfectly clear that the invitation must be declined. It also demonstrates what Lord Sumption said in Benker Bush, at paragraph 34, which I took to you previously, where Lord Sumption says that Lord Brown gave a tentative endorsement to tenability. Clearly it is tentative. At paragraph 65, he says, although, as I've acknowledged, there are occasions when the court will decide questions as to the state's obligations under unincorporated international law, this, for obvious reasons, is generally undesirable. And my lords, that does not appear to be good law in light of Lord Sumption's judgment on behalf of the entire Supreme Court in Benker Bush. There's no general rule of tenability, there's no general rule of abstention. And in fact, this court, in the Law Debenture Trust in Ukraine case, I don't think we need to turn it up, but It's at tab 24, and I just want to draw your attention to one paragraph for your note. At paragraph 163, page 1280 of the bundle, there's a whole lot of examples there given about when an English court will decide questions of international law as questions of law. It's not a definitive list, but it gives a flavour for all the different types of situations where that is appropriate. And actually it leaves out an important category, which I've taken you to, which is the interpretation of unincorporated investment treaties based upon the Occidental Petroleum.
So I missed the reference.
It's paragraph 163, page 1280 of the bundle. But moving further down Lord Brown's judgment, paragraph 65, he refers to the fact that the OECD has its own dispute resolution process. My lords, one has to be very clear about this. These dispute resolution processes in treaties are very seldomly used. And the decentralized system of international law relies upon national authorities to interpret treaty provisions, to give guidance to the executive. It's also inconsistent with the statement of principle in the Adan case. And I do want to take you to this one. So tab 36...
What are we doing here, Mr. Douglas? I'm sorry, I'm a bit confused. We're looking at Lord Brown, but every 5 seconds you say this is wrong because let's see another case. Could we look at Lord Brown and then you show us why he's wrong in every particular? But I can't jump backwards and forwards because I keep on losing the page.
I'll do my best,
Just show me. I mean, if you could just, I mean, by all means, as you go along, say 65 is wrong because of Ukraine, but I didn't even manage to catch up with Ukraine, see what Ukraine said, and come back before you'd moved on to another paragraph. And if you want me to understand, I realise that may or may not be necessary, but if you want me to understand your submissions, you've got to take them at a pace that I can follow.
And can I say, on a similar theme, you carry all the international law cases in your head. I don't. So if you refer to a case obliquely, please don't assume that, as any fool know, it means X.
We don't teach international law.
It's just that my discipline's under siege at the moment.
No, it's not. We're in awe, Mr. Douglas, but that doesn't necessarily mean that we can travel at your speed.
My lords, I will go through each point then, and then come back to contrary authorities.
Please, yes. So I'm on paragraph 65. That you've told me that Lord Brown is wrong to say that although there are occasions where the court will decide questions as to the state's obligations under unincorporated international law, this is generally undesirable. That's wrong because there are
the courts do it all the time.
We do.
Courts do it all the time. The next point is that we probably shouldn't give an interpretation of the OECD Convention because there's a dispute resolution mechanism in that treaty.
Oh, yes.
And I was going to take you to another case that makes the contrary point. I'll come back to that case so as not to interrupt the flow.
Right.
But my point was just generally that international law is a decentralized legal system. There is no central parliament, there's no central executive, there's no central court system. And for international law to remain effective, it has to rely upon national courts doing the work, interpreting the treaties, giving guidance to the executive.
Your point there is that the fact that there's a dispute resolution mechanism in the treaty where the parties to the treaty fall out doesn't tell you anything about when a national court needs to decide whether the government has said a treaty is going to be complied with or not.
Precisely, my lord. Precisely the point. The general point, I guess, as well, is that so long, it can't be right that so long as there is an international mechanism, when it's not invoked, that the application of the treaty is put on ice in the domestic legal system. And it's no accident that courts have tried around the world to interpret the Paris Agreement. Right. It's also wrong, and this I may be putting too much into Lord Brown's words here, but he seems to be suggesting that the English court should decline from interpreting the treaty because the English court can't decide for other contracting parties to the treaty at the international level as to what the correct interpretation is.
Well, Lord Justice Stuart-Smith said something similar.
He did.
He said the Paris Agreement is a very important treaty, and it's not for me sitting in London to determine this meaning of it for the benefit of all the 100 and whatever signatories.
Near 200 parties. He said precisely that, my lord, at paragraph 124. And my lord, as a matter of international law, that's just not correct. Whatever this court says, with all greatest respect, about the Paris Agreement does not bind anyone apart from the British government. An English court's decision on the interpretation of a treaty does not bind other parties. It does not bind any court, international court.
But it may not, but you would agree, wouldn't you, that for the Court of Appeal of England and Wales to say what the Paris Agreement means might be considered quite a serious thing to do.
It is a very serious thing to do, and we encourage the court to do so. But again, the only risk is, my lords, that the rest of the world will find what you say to be persuasive, and may follow you in the way that they interpret the.
There's another risk that judges often consider, Mr. Douglas, and that is either that another court will think that we're wrong, or indeed that these other states will think we're wrong.
And that's
you say we're not to be deterred by that. That's our job.
That is your job, and that is part and parcel of the decentralised system of international law.
And our job also entails discerning the single universal meaning of the treaty. Is that right?
You're quoting from the Appellant case, which
I wasn't consciously doing that. I was simply formulating the submission in my own mind. I wasn't conscious I was doing that.
I'll take you to that passage because it makes that precise point, and it may be useful for you to see it.
I didn't know that.
Perhaps I could do that now, with the leave of the court. It is tab 36.
I tried, Mr. Douglas.
So I've got to take the hints when I get them.
Is this the Adam case?
This is the Adam case.
Where do we find that?
And that's at tab 36. This is a judgment of Lord Steyne, whose name I will now pronounce correctly forever. And it's at 2057 of the bundle.
Hang on, it's not a judgment of Lord Steyne, it's Lord... Oh, it is, I see, in the Supreme House of Lords, yeah.
I hope I wasn't just making up to get his name right.
No. But he has a daughter who sits on the bench now, so she also likes her name
Pronounced correctly.
in the same way. Well, correct.
If we go to 2057 of the bundle, this is page 516 of the report. The context here, my lords, is the interpretation of the Refugee Convention. It's not incorporated into English law, but there is a domestic statute, the Asylum and Immigration Act, that makes reference to it. So there's a domestic foothold to interpret the Refugee Convention. And you'll see at paragraph 516, Lord Steyne quotes Article 31 of the Vienna Convention. Again, same starting point each time.
So is this page 516 internally?
This is page 516 of the report. Yeah, this is before the days of paragraph numbering.
So page 2057.
That's correct.
Yes.
And so he starts with Article 31 of the Vienna Convention, and you'll see the constant theme here. That's what you need to do to interpret a treaty. And then he says at paragraph H the following. It follows that, as in the case of other multilateral treaties, the Refugee Convention must be given an independent meaning derivable from the sources mentioned in Articles 31 and 32 of the Vienna Convention, and without taking colour from distinctive features of the legal system of any individual contracting state. In principle, therefore, there can only be one true interpretation of a treaty. If there is disagreement on the meaning of the Refugee Convention, it can be resolved by the International Court of Justice, Article 38. It has, however, never been asked to make such a ruling. The prospect of a reference to the International Court of Justice is remote. In practice, it is left to national courts, faced with a material disagreement on an issue of interpretation, to resolve it. But in doing so, it must search, untrammeled by notions of its national legal culture, for the true autonomous and international meaning of the treaty. And there can only be one true meaning. Now, finally, before we leave Corner House Research, I did want to draw your Lordship's attention to paragraph 66 of Lord Brown's judgment. And this is, I think, at page 792 of the bundle. And you can see he's distinguishing Launder because the director of the Serious Fraud Office would have made the same decision regardless of whether or not he was right or wrong on the interpretation of Article 5 of the OECD Convention. And he says that all that he and the Attorney General were really saying was that they believed the decision to be consistent with Article 5. This clearly they are entitled to say was true, and at the very least, obviously a reasonably and tenable belief. But my lords, why was it a tenable belief? Lord Brown doesn't offer any interpretation of Article 5, so we don't have a benchmark for judging the range of tenable views. Now, we would submit that what Lord Brown appears to be saying here, remember, this is the first time that anyone talks about tenability in any court. What he seems to be saying is that he was satisfied that the director held a sincere belief about the compatibility of his decision with Article 5.
And what's wrong with that? I mean, just take a case away from this situation. The minister has to make a decision about all sorts of difficult things as to where government money should be put. And they have to take into account unincorporated treaties. Why, I mean, I perfectly understand the Tameside point that, you have to get the information you need. But let's say that learned counsel, like Sir James, comes along and says, I've no idea what this treaty means. It's incredibly complicated. It could be, it's entirely tenable to say it's consistent, but it might not be. Why should the British government not be permitted to say what Lord Brown is really saying, they'd said in that case, which is, we think our best view is that this is consistent with the treaty, and we're going to proceed on that basis. Why should that be reviewable?
My lord, the starting point is that it's perfectly open to the decision maker to say, I'm not taking this into account.
No, but they want to take, I mean, perfectly properly. Governments don't want to, I mean, I'm assuming governments don't generally want to break the treaties they've just made. But they may also find it difficult. I mean, Lord Justice Stuart-Smith found it difficult to say what this treaty meant, and he may or may not be right. But what I'm asking is, surely we have to be careful about government decision-making processes. The court is not here to review everything that the government does, like school boys or girls, and say, you've done this, you should have done it this way a little bit better, and so on. And I think I've given a judgment recently about that in a case, to a different case altogether. But I don't quite understand why it isn't. I mean, I understand you might say that's not what happened here. That's a different point. But why is it not open to the government to do what Lord Brown is saying, to say, when we've looked at this, we think it's a fairly good arguable case that this is compliant, we're taking it into account, we think it's a good arguable case it's compliant, and why should that be reviewable if it turns out on a hard-edged interpretation of the treaty they're wrong?
Because it's a question of law. And like any other question of law, the courts are sovereign as to what the correct answer to that question of law is.
Well, why can't the government say, I've taken it into account as best I can, I can't get a final legal determination of this treaty without going to court, which I haven't got time to do, and I've got to take a decision.
Well, then, my lords, the decision maker can simply say we have taken it into account and go no further. But once you make
That's what they did say.
no, they made a positive, affirmative statement that it was compatible with the Paris Agreement. And in our submission, if the other ministers who
But
clearly
I'm sorry to interrupt you, but I mean, my understanding, it may be wrong, I'm quite happy for you to tell me it is, but my understanding is not that they said they made a firm decision that it was compatible. They said they took a view. They said they had taken the view that it was compatible, which is a different thing from saying it is compatible as a matter of law.
well,
And why can't governments do that? I mean, it's rather less cumbersome than the approach you're
But I would submit that it's no more or less cumbersome when a decision maker takes a stand, let's put it in a neutral way, on a question of law. Then it has to be for the courts to decide whether the direction as to that point of law was correct.
What I'm putting to you, because I think this is slightly the crux of the case, is that Lord Brown, and it's quite characteristic of Lord Brown, puts his finger on something that quite a lot of other people don't put their finger on, and that is that even if the government says this is compatible, what they mean is we think it's compatible on the best we can do in the time available and with the material available is to take advice from learned leading counsel, and we're told it's a tenable view, we think it's compatible. And he says that is an undesirable decision for the court to have to review on the black and white legal basis that you're trying to review it on.
My lord, the function of the courts is to give guidance on questions of law. And the point of judicial review on questions of law is to allow the decision maker to make a decision on the correct basis of law. And this is the difficulty with the respondent's submission, that the whole purpose of this tenability review is to shield the decision from judicial review. But that puts judicial review on an antagonistic footing with the decision maker. If this court were to quash the decision, then it will be open to the decision maker in this case to say, well, actually, I'm not going to take into account the Paris Agreement on this occasion.
No, but it could be that Lord Justice Stuart-Smith, now you've taken me so carefully through his judgment, was actually right. Because it could be that he said, look, I've looked at this, I don't actually have to decide whether it's actually right that the proper construction, interpretation of the treaty is as the government thought it was. It's sufficient for me to decide that was a tenable view, because that's all they were really saying.
But how does one get to a tenable view without knowing the correct view?
Well, I mean, I don't know how much counsel gives legal, I don't know how much professors of law give legal advice these days, but counsel is very familiar with writing opinions, at least they were when I was at the bar, which I agree.
Which are caveated.
Which say, I'm not sure what the answer is, but I think the best view is this.
But again, my lord, surely a government department in making a difficult decision like this wants to get it right. If that's what they're saying they're doing, if they're embarking on a process to come to the correct view on something, they want to get it right, and if they get it wrong, they want an opportunity to reconsider.
But I mean, I'm not going to, I'll shut up now, but when we go through the briefing to ministers, which is I think where we find what they acted upon, the briefing to ministers says there are risks both ways here. There's a risk of being challenged. We've asked counsel whether we're going to be challenged, and counsel says it's a 33.33% chance you'll be challenged for having committed and not gone along with it. And there's a risk of being challenged by Friends of the Earth if you decide to go along with it, and that risk is 43.25%. I mean, I'm joking, but you know what I mean. And the balance of risk lies here. So it was pretty express that ministers were acting on a balance of risk. So isn't that really nothing more than acting on a tenability approach?
But my lord, you're assuming that it would somehow shut down government if you were to provide a legal interpretation of the Paris Agreement, and then the decision maker would have an opportunity to consider that view and decide.
That can't be done between the 29th of June and the 30th of June 2020. And also, it's not what...
It could have been done much earlier, perhaps.
I mean, they don't come... I mean, government does not come to this court for advisory opinions.
No,
Well,
that's certainly
I
true.
mean, Sir James comes to this court a lot, but I don't think he comes generally to ask our advice.
My lord, this would be a unique situation where a court of law says that an illegal issue is justiciable, but we're not going to decide what it is. It would be unprecedented in that respect. You would create
I'm not saying this is not an unprecedented case. This may well be. Okay, anyway, that's very helpful. Thank you.
We get back to the fundamental contradiction. This is perhaps a footnote to the discussion that's just been had. That where a decision maker has represented that his decision is compatible with an unincorporated treaty obligation, the court cannot then in judicial review say that in answering that very same question, it would be too controversial or difficult, or the obligation was too vague or soft around the edges. If the court can't do it, then how did the decision maker do it? Now, in Cornerhouse research, the decision maker said that he would have reached the same decision regardless of whether or not it was compatible with the UK's obligations under the unincorporated treaty. And the House of Lords, in fact, went further and found that it was the only decision that could have been taken under the circumstances, given the grave threat to British security. There was also, in that case, a profound justiciability problem because the court was being invited to trespass directly into the conduct of foreign affairs with the Saudi government. Now, none of those factors are present in this case. That's why justiciability has been conceded. Now, my lords, time will not permit me to go through the first instance decisions where tenability has been raised. I'll come back to it in reply, perhaps, but just very quickly, put down a few pointers. The ICO against Ofcom case. I'm not going to take you to any of these judgments, but I just want to tell you how they can be distinguished. That's tab 17 of the bundle.
Sorry, just before we go there, have you left Lord Brown?
I have.
You're really saying Lord Brown 65 to the end is all wrong, wrong, including his endorsement. Of
no, my lord. What I'm saying is that what he says is relevant to the question of justiciability.
But only that.
Only that. And we may have difficulties with what he says about justiciability. For example, the inference he draws from the fact that there's an international dispute resolution process, so therefore the court shouldn't pronounce on that question. I've told you what the difficulties with that approach is on the basis of the Adan case. But all that, in a way, is beside the point because everything he says is about justiciability. And he says it, and he endorses Sir Philip Sales' then was article, but Sir Philip Sales says himself he was worried about the launder principle being extended and going too far. And that's, in that context, he introduces tenability. I'm sure you'll be taken to that article at great length by my learned friend. But that was the context. He was worried about launder going too far. We don't need to worry about that here because we're in the four corners of launder, binding authority, it's justiciable, you apply a correctness standard.
Thank you.
So the first instance decisions, the ICO against Ofcom case, in that case, the decision maker did not represent that the decision was compatible with an unincorporated treaty. So in other words, the issue was not justiciable. Anything said about tenability there is over. In the Stonehenge case, that's tab 29. Again, no representation by the decision maker that the decision was compatible with an unincorporated treaty. And in fact, the correctness standard was actually applied. That leaves the third first instance decision, the Elliott-Smith case. That's tab 28 of the bundle. In that case, there was a lot of speculation about whether the Paris Agreement was taken into account by the decision maker. It appears that it might have been. It's not entirely clear from the report, but tenability was applied to the interpretation of the Paris Agreement. And as I forewarned, that resulted in was no interpretation of the Paris Agreement being given. And the other difficulty with that decision is that the Launder line of authority was not cited to the court, and nor was the Benker-Bush Supreme Court decision.
Just pausing for a second, and without, I hope, creating a tangent that needn't be there. There is the whole question of what interpretation is. What, on either view of the correct approach, should it entail? I mean, clearly it has to go beyond mere paraphrase. But on either view, this court looks at the words of the treaty, in particular Article 2, to discern meaning. That's common to both proposed approaches. But the words are what they say, ultimately. I mean, what you don't make submissions about the nature of the exercise entailed in interpretation as such. You're going to come on to that. You're going to come on to that.
I rather hoped I'd already been there. So it's Article 31 of the Vienna Convention.
Yeah, but I mean, you don't take it beyond what is stated in Article 31.
Oh no, we will come back to that
right.
in due course.
Okay, well you're going to do that.
And of course, we endorse the analysis that's provided by Justice Thornton, applying the Article 31 criteria of text, ordinary meaning of text, in the context, in light of the object and purpose.
Well, is that, maybe that's not controversial as such.
But I certainly don't think the approach to treaty interpretation could be controversial.
No, fine.
Now, my lords, there was a question asked about the SC against Secretary of State for Work Pensions case. And again, distinguishable because the court found that the issue was non-justiciable. Remember, the issue there was whether the court could decide whether the UK had breached the unincorporated UN Convention on the Rights of the Child in determining whether legislative amendments were compatible with the European Convention. That is not a case where there was any sort of representation that the decision was being made in accordance with the UN Convention. And of course, tenability is not mentioned in that judgment. It's all about justiciability. And the other thing that bears mentioning is that the paragraph that you referred to, my lord, was about the tin council type argument, parliamentary sovereignty. In Launder and Kebeling, the court expressly rejected that argument based on tin council in saying, no, when a minister says that the decision is in compliance with an unincorporated treaty, that gives rise to judicial review based on error of law. Perhaps finally...
I think the case I was referring to, I mean, I did have SC in mind as well, but was Friends of the Earth.
Ah, Friends of the Earth.
Secretary of Transport.
My lord, I'll say something very similar then, because in that case, it was found that the Secretary of State was not obliged to take into account the Paris Agreement, and decided in his discretion not to take them into account. So again, we're talking about justiciability again. There was no domestic foothold to interpret the Paris Agreement obligations in that case.
Well, I mean, I'm concerned about paragraphs 70 and 71, where the what the court said about the interpretation of the Paris Agreement does not seem to, anyway to me, to align very easily with what you're suggesting as the proper interpretation, because it says in 71, I think it's Lord Sales and Lord Hodge, notwithstanding the common objectives set out in Articles 2 and 4.1, the Paris Agreement did not impose an obligation on any state to adopt a binding domestic target to ensure that those objectives were met. Now, I know it's not precisely the same point. The specific legal obligation was to meet any NDC applicable to the state in question.
I don't want to trespass.
I can help you on that. We don't, in any sense, dispute that, and they are actually conducting the exercise they're obliged to do in interpreting what Articles 2 and 4 mean, and correctly in our submission.
Right, okay. And you say it's not relevant to the specific issue that you want us to interpret. Okay. Right. Well, you'll come back to it, Miss Seymour, if necessary.
Simon will come back to it. And just to be clear, though, in Friends of the Earth, nothing is said about how interpretation should proceed. It's questioned simply of the justiciability of the point. Perhaps finally, could I take you to the Heathrow Airport case, about which much has been made, and this is at tab 27 of the bundle.
Well, that's the VAT case.
The VAT case. And it's at page 1559, paragraph 99, that we see the international legal issue which is going to be debated. And summarised in the following way, the government adopted the firm position that upon expiry of the transitional period, it was bound by the GATT to ensure that the domestic law VAT regime adhered to the non-discrimination principle. And then paragraph 100, just to put everything in context, said, in their very detailed written submissions, they argue that the government misconstrued the GATT. A bit further down, had it applied the law correctly, then it could well have adopted one of the solutions argued for by the claimants. So the issue here, at the moment at least, is the justiciability of interpreting the UK's obligations under the GATT as an unincorporated treaty. And if I could skip down to the conclusions on justiciability, this is at page 1583, at paragraph 165.
Incidentally, is this case on appeal? No?
I'm afraid I don't know the Heathrow Airport case. The whispers tend to suggest that it's not.
I'm getting a negative.
A negative whisper.
I think it's difficult.
And so at paragraph 165, Lord Justice Green divides two sets of factors, grounding and intrinsic non-justiciability. As having reviewed the case law and the parties' submissions about it, I now apply that case law to the facts of this case. Two main considerations which flow out of the case law are therefore the extent to which the GATT has been grounded into domestic law, grounding, in other cases called the domestic foothold, and secondly, whether there's anything about the GATT which makes it unsuited to adjudication, intrinsic non-justiciability. And at paragraph 166, probably don't need to read it, but you see there, in setting out various considerations which are very familiar to those that Lord Brown talked about in Corner House research. But again, the context here is justiciability. He then concludes at paragraph 177, page 1586. When set out in the context of the case law, these factors individually and cumulatively point strongly in favour of the issue of law being justiciable. The next question is as to the standard of review to be applied. And then he goes on to reject tenability as the standard to apply to a justiciable legal issue. You see it, paragraph 181, page 1588, says this, Ms. Patel for the government argued that whatever tenability meant, it implied some lower standard of proof for the decision maker than correctness. Taken to its extreme, this argument presupposes that the government could have adopted a tenable but ultimately wrong position on the law in circumstances where the court was well able to decide the points arising. When this argument has been advanced in the past, but outside the context of unincorporated international law, it has been met with a strong principled riposte and objection that, if correct, It would undermine the rule of law. And then at paragraph 182, Lord Justice Green says this: standing back, if the court is able to address the issue, which it is, and is in favour of a decision maker, then it seems unsatisfactory to say only that the government's position was tenable. That risks fostering legal uncertainty at the international level, damning with faint praise. If the government is right and a court can determine as much, then it accords with the rule of law to do so. As already explained, GATT member states are responsible for the decisions of their courts. If a court found that a decision maker's position was tenable, even though on deeper analysis it might be wrong, this could expose the state to proceedings under the GATT. So, my lords, the court was correct that the correctness standard should be applied, but we have difficulties with the impression that the court gives that it will only do so when the government is right. And once again, it illustrates the incoherency of the tenability approach. You still have to start with the proper interpretation of the treaty. If the government's position is correct, then on the Heathrow example, the court will say so. But if not, it will say that it's tenable or perhaps not tenable. But in either case, the inference is going to be that the government got it wrong. To conclude, my lords, the only cases in which a tenability standard was actually applied to a justiciable issue relating to the interpretation of an unincorporated treaty was in Lord Justice Stuart-Smith's judgment below, and possibly the first instance decision in Elliott-Smith. What Lord Brown said in Corner House was, of course, strictly obiter, as we've said, but also relevant only to justiciability. The Launder line of authority makes the issue in this case justiciable, and that's been conceded. And the same line of authority requires that the standard of correctness be applied to a challenge based on an error of law. We say that the adoption of a tenability standard to a justiciable issue is not only contrary to binding House of Lords authority, but it's incoherent. Because a sliding scale of review of a legal question just doesn't work. There's only one approach to treaty interpretation, it's the Vienna Convention, and that doesn't contemplate some sort of sliding scale. And you can't have separate approaches to treaty interpretation depending on whether the treaty is incorporated or unincorporated, because it's the same text. The problem is that the courts will relinquish their constitutional function of providing guidance to executive decision makers on questions of law. And courts applying a tenability standard, their decisions will have no precedential value. So every time the government is taking a decision which they say is consistent with the Paris Agreement or any other unincorporated treaty, it will then be open again and again to de novo examination and judicial review as to whether or not the interpretation is tenable enough on this sliding scale of review. And a latter court won't be able to rely upon what an earlier court said about the same obligations. It also raises the prospect of different ministries justifying their decisions on different tenable but conflicting views of the Paris Agreement or some other treaty. And the courts will be impotent to provide any real guidance.
Can I just ask you, before you finish this line of argument, this question? Is it or is it not open to government to say, in taking a particular decision, that it wants to comply with the treaty, but having received legal advice, it can't be certain what it means. It thinks on balance that the decision is compliant with it, and in that situation its decision would not be open to review, even if a later court decided that the decision actually on analysis was wrong.
My Lord, obviously we're not in that case, but if we were, we'd be very close to the corner house research situation, where the decision maker says, here's my interpretation. I think it is incompatible. I think it is compatible, but in any event, I'm going to reach the same decision, whether or not it is.
Ms. Seymour might want to say a few more words about why that's not the real import of the ministerial briefings in this case.
I look forward
But I don't think
Ms.
it'll
Seymour
be,
addressing
that's
us.
not for you, I guess.
In our view, our submission, the tenability standard review is unacceptable because it allows a minister to assert that a decision is compatible with the UK's obligations, and then in judicial review proceedings, claim that those obligations are too vague, soft-edged, contradictory and aspirational to justify a legal interpretation by the courts. If a minister represents that his decision is compatible with the UK's obligations, then the court must have the jurisdiction to review the correctness of that decision. The court's constitutional function must entail having the last say on the interpretation of the law. And it's only then, my lords, that the mechanisms of political accountability can function properly. Parliament can be confident that ministers are directing themselves properly on the UK's international obligations, and so can the general public. We don't know and cannot know whether the ministers in this case would have agreed to the financing of the project had they been told that it was not compatible with the UK's obligations under the Paris Agreement. What we do know is that it's very likely they would not have agreed, because the UK had the presidency of COP and was urging other countries to end financing for fossil fuel projects at that very time, and that the Foreign Secretary, the Secretary of State for the Department of International Development, and the Secretary of State of Business, Energy and Industry Strategy were all against the project. This court does not need to speculate. If there was a misdirection of law, then that is enough.
My lords, just to pick up on Professor Douglas's helpful submissions. First of all, in relation to treaty interpretation, there is no dispute between the parties that the appropriate approach is the Vienna Convention, and both parties rely on the Al-Malki and Race case, which is in Core Authorities Bundle 2, tab 20. And we both rely, and it's in our supplementary skeleton, on paragraphs 10 to 12.
Sorry, it's not tab.
It's tab
22.
22, apologies. So it's paragraphs 10 to 12. And both parties rely on those paragraphs as setting out the correct principles of interpretation of international law.
Just a second, if you will.
Now, my lord, one must not assume that the government as a whole, the various ministers, would have continued with this project had they been informed that it was not compatible with the Paris Agreement. One can assume, perhaps as a matter of good faith, that ministers want to be properly directed on the law and want to make their conclusions as to whether to use UK money in this way, generally in compliance with international law. Indeed, there's the authority to support that. But also one can assume it. Here we had dispute between ministers in government, and we had a finding. I took you to the ERIC report, where they asked that reference be put into the Paris Agreement into the climate change report. So if you could go to core bundle, supplementary bundle 1, page 283, you'll see in the second paragraph, gas from the project is also considered by the government of Mozambique to be an important contributor to the energy transition of Mozambique, in line with its NDC and its Paris Agreement commitments. This aligns with the UK's commitment to support developing countries to respond to the challenges and opportunities of climate change as part of its own Paris Agreement obligations. The Paris Agreement also recognises that the global peaking, etc. If we then go to 296...
So what is this document we're looking at?
This is the climate change report. And you may recall that at the beginning of the submission to ministers, particularly the Secretary of State for Trade, she was advised to read this document particularly carefully due to the disputes between the various ministers. And reassurance effectively is provided here that it is compatible with the UK's obligations under the Paris Agreement, which is actually unsurprising since at that time we were president of the COP. And it was unlikely that at that time a minister would have wanted to take a decision that put the United Kingdom in breach of the Paris Agreement that it was seeking to further in Glasgow. If we then go to page 298, you'll see at the top of 298, summary. The project has a significant impact on the country's emissions, but is still considered in alignment with Mozambique's stated climate policies and by extension with their Paris Agreement commitments. And when I take you to the Paris Agreement, I will show you that there is an obligation on developed countries to further compliance and achievement, and indeed ratcheted up ambition of developing countries. And then if we go back to 283, we go to 296. No, I want the question. Written down the wrong number. There is a question in this report. Yes, sorry, page 302. And Mrs. Justice Thornton relied on this. In the process of answering this question, consider whether the project, and then the third bundle on page, third bullet on page 303 says it is compatible with the Paris Agreement, i.e. to reduce emissions well below 2 degrees centigrade with effort to limit to 1.5. And then if we go to the detailed grounds of defence.
Well, wait a minute, what's the answer to that question?
Well, then there's just general talk. I'll take you to this later, but there's general talk about it. So there's not a categorical yes or no there.
You've shown us other references where
Yes.
there was a categorical statement.
Yes,
think.
I gave, those were the other references.
So those are
Yes.
the salient references.
Those are the references.
Right.
And then, but what she points out is that the government was asking itself the correct question. And then if we go to detailed grounds of defence, I haven't got the tab, hold on.
Core bundle.
Yeah, core bundle, I think it's at the 15, thank you. Paragraph 117.5. No, that's
117.5.
not the right one.
Detailed grounds.
Page 377.
Sorry, that's not the right reference, is it? You know, what I'm going to do is I'm going to check the references overnight, if you don't mind, and I'll take you to them in the morning. In any event, my lords, you'll be aware that that it is accepted, as far as I understand, it has been accepted, and I will take you to the references, that the decision proceeded, the ministers proceeded on the basis that this project was compatible with the Paris Agreement. Not, as my lord suggested, we're not sure. We think it's very difficult to determine. We will, in any event, proceed, irrespective of whether it is, but we are satisfied to a tenable standard that it probably is.
Well, what's all that stuff about balance of risk in the ministers' briefings? Then
That balance of risk, as far as I understand, is about. Well, you mean in relation to litigation?
yeah.
Yes.
It was in the Prime Minister's briefing.
Yes.
And there were two considerations. One was the likelihood of a challenge, and the other was the
Yes.
defensibility of a challenge.
Yes.
And there was a convergence on the view that whilst there was a greater likelihood of a challenge if you went this way, i.e. the way that they did go, the defensibility of that position was stronger than if you didn't. That was said to the Prime Minister on the eve of the decision, I think.
So that's, as we're all aware, when one provides legal advice, that one's 80% sure, or usually 65% sure that this is compatible with the Paris Agreement. Now, if the government had said that there's a 65% or whatever, but the position, as I understand it, was that they went ahead and were advised on the basis that this is compatible. And that had they been advised to a 65% chance that it was not compatible, it would not have gone ahead. And that's where the courts come in. Because, in fact, the ministers and the government is entitled to take their decision on a correct legal basis. And only the judiciary can determine what is a correct legal basis. Now, if your lordships determined that this was not compatible with the Paris Agreement, it would be open to the government to retake exactly the same decision. But they would be doing it on a correct legal basis, because only the judiciary can decide what is correct. And with the greatest respect to Sir James, an opinion from Sir James is not equivalent.
No, of course not. But how can the government ever take a decision in the case of doubt?
No, because like one often takes a decision. In fact, any advice that one has given to government, but then there is judicial review as to whether it was based on an error of law or not. And there's no actual difference between domestic law and international law for those purposes once past the justiciability threshold. It's exactly the same.
I mean, the courts don't micromanage.
But they do.
I mean, we gave a judgment just the other day in a case about against the Prime Minister about WhatsApp messages and policies. You know, we don't look at every document the government issues and say you're bound by that and that's absolutely binding and legally enforceable. It has, judicial review is not, as I say, micromanaging the way government operates.
No, but my lord, the first sentence of the important paragraph in Wednesbury by Lord Green is a misdirection as to law. And the reason a misdirection as to law is vitiates a decision is not micromanaging. It's because ministers wish to take decisions lawfully, and indeed are bound to do. If the position is that in this specific case, the decision was taken on the basis of a misdirection of law, as I've said, the United Kingdom may decide, the government may decide, to nevertheless go ahead with this on the basis of a correct direction as to law.
Has the money actually been paid out, or has it been frozen pending
I'm not
this
sure.
litigation?
Unfortunately, we had agreed to expedite and roll up the hearing in September 2020, but Mr. Justice Swift called us in and pulled that apart, and so we ended up having a paper refusal, an oral renewal, and a full hearing. But what Mr. Justice Swift said is this does not warrant expedition because the loan can be unwound, and the respondents agreed with that.
Well, so the loan has been made.
I'd have to.
The money has gone from the UK government to Total.
But that was something that was agreed. So we obviously wanted expedition in order to prevent the money going. But it was said by Mr. Justice Swift that there was no problem with this being unwound, and there was no dissent from the respondents.
Can I just take you back a step in those exchanges? We've looked at a number of documents where there are statements are made about compatibility with the Paris Agreement. Are all of those references properly to be described as advisory statements? Or are any of them declaratory or definitive statements of the government's position as such?
Sorry, which statements are asking about?
Particularly the references you took us to in the climate change report, 283, 298 and 296 in particular, but also 303.
So I am not. We got the climate change report through disclosure.
Yeah.
So as far as I know, it is not a publicly available document.
No, but that was a report that gave advice or
Yes, it was advice.
expressed conclusions
It was advice.
on a questionnaire basis partly.
Well,
You showed us.
yes.
You showed us the questions and
Yeah.
some of the answers. How is that translated into some statement of the government's basis for the making of the decision as such? Or does one have to infer that, absent anything else?
Well, our challenge is to a misdirection of law.
Of course.
So whether there is actually, if I remember rightly, there is a statement by. I have to read that statement in Parliament again about.
Well, I mean, there's the classic proposition that officials advise and ministers decide.
Yes.
And that's what I'm driving at.
But if they're advised with a misdirection of law, the decision is vitiated and they can retake it. What we have not had, and I believe, again, my memory is failing me, but I do believe we may have asked them in the Part 18 request whether they would nevertheless have gone ahead. And we have never had a statement that even had they been directed that it was incompatible with Paris, they would have gone ahead. And I believe Mrs. Justice Thornton refers to that.
Right, so we don't have a corner house scenario in that sense. We don't have that
No.
component of the corner house picture.
No, we don't have any statement, any evidence from the respondents or the ministers directly saying that had they understood that this was incompatible with Paris, they would nonetheless have agreed this financing.
Thank you.
And in our submission, they would not, because apart from anything else, we were head of COP.
Well, yeah, but that's inferential, isn't it?
That is inferential. That is a submission, an inference that, but you know, that is not necessary for our case.
Yeah, well, the politics of COP were being displayed in the exchanges you showed us earlier on.
Yeah. In any event, for our purposes, we say that all that is necessary is a misdirection, and there is no evidence from the minister saying that had they understood, that they would have nonetheless taken the decision, or even that they did understand.
So, where is the misdirection? Precisely. Which misdirection do you rely upon? I mean, I've just been looking at the briefing to the Prime Minister.
The Prime Minister doesn't matter so much because he wasn't necessary for the decision, technically.
Well, technically, as I understand it, this decision was of Mr. Taylor, and he had to have Treasury consent, but he didn't, as a matter of law, have anybody else's consent, but clearly
Yes,
he had to have government consent.
He had, well, I showed you paragraph 3 of the original briefing of Mr. Taylor to the Secretary of State. And there it said that you have refused, as a minister, to give me your delegated authority on fossil fuels so I will take the decision. And therefore we say that that is an operative and essential decision. He could not, for example, afterwards have said, well, I don't need to go back to the minister. Now I've been told something different. He would have to have gone back before exercising that decision. The Chancellor had to give his consent, and quite rightly, as you say, the other ministers who got involved, that at a technical legal level was not relevant.
I thought DIT had to give. I thought
Yes, the Secretary of State for Trade. That was she did have to give.
She had to give.
And she's the one who says in paragraph 3, or it said to her, you have refused to give delegated authority on this without her taking the first decision.
Yes, but where is the statement that is wrong in law?
It's in the climate change report, which she is referred to and asked to read specifically and to pay particular attention to.
In the passages you just drew
Yes.
attention to.
And the defendants have, in all their submissions, and we will get you all the references, said that this finance is compatible with the UK's obligations on Paris. So it has not been said subsequently, we were never saying that.
No. So just to be absolutely clear, when one wants the substantive decision making, which is spotlighted in this challenge, it really is in the passages you took us to a few minutes ago, in the climate change report. That is the manifestation of the decision making which is truly under attack in this challenge.
Yes, plus the evidence from Mr. Taylor and the detailed grounds, which also, with a statement of truth, constitute a form of evidence, if you like, as to what actually happened and what they say is the position. So the respondents have never said, we did not believe that this was compatible with the Paris Agreement, or we were not sure whether it was compatible with the Paris Agreement.
Well, you say that, but it's inevitable, isn't it? That it's not about Mozambique's compatibility with the Paris Agreement, it's about the UK's compatibility. And the passage that you took us to is at page 283, I think, where it says, gas from the project is considered by the government of Mozambique to be an important contributor to energy transition of Mozambique in line with its commitments, Paris Agreement. This aligns with the UK government's commitment to support developing countries to respond to the challenges and opportunities of climate change as part of its own Paris Agreement obligations. Now that is not saying, that basically says it's not about 2(1)(c), it's about supporting developing countries to respond to the challenges and opportunities of climate change. And that doesn't seem to form part of any of the Divisional Court's judgments.
Well, it is. I think, my lords, it's going to be important for me to actually take you to the Paris Agreement, for you to understand that the Paris Agreement incorporates obligations also in relation to NDCs in developing countries.
Yes. But the point I'm trying to get to just at the moment, before we do that, is what is the legal error? And that is the only line in the climate change agreement that you say then is false and wrong in law. Is it?
That's the same. The position is summarised in the judgment of Mrs. Justice Thornton at 262 to 268. But my lord, it is important that I get onto the Paris Agreement, because you can't really consider all this until you've understood the Paris Agreement.
No, I mean, I understand you say that, and I'm delighted for you to get on to the Paris Agreement, but I just want to be clear, when the government took a decision to proceed with the project, what basis you say they took that decision on and where that's recorded, so that I can evaluate the argument we've just been hearing from Mr. Douglas as to the question of tenability, or what exactly it was deciding. Because it might have decided, I mean, I know it didn't, we don't care what's in the Paris Agreement, we're going to take this decision anyway, and we'll make a public announcement about complying with the Paris Agreement later. I know it didn't do that, but it's important to look at what it did do. And that's my question. Now, I'm looking at 268, which I think you said the answer was in 268 to 270. Of the judgment. Did you say that?
So, my lord, our position is, as explained by the defendants, that the Secretary of State was advised that the project would align with the UK government's commitment to support developing countries to respond to the challenges and opportunities of climate change as part of the UK's own Paris Agreement commitment.
Well, are you reading, is that a paraphrase of what's on 283 of the...
Well, it actually comes from Mr. Taylor's witness statement, but it's effectively a paraphrase.
Well, yeah, let's just look at 283, because we alighted there for a second and then moved off. The relevant passage on 283...
This is judgment.
No, this is the climate change report.
Okay.
It may not be the right reference, but it seems to be the relevant one on 283, doesn't it? It's the first full paragraph, isn't it, on that page?
Yes.
Begins with the words gas from.
Yeah.
That reads, Appellant project also considered by the government of Mozambique to be an important contributor to the energy transition of Mozambique, in line with its, that's Mozambique's, NDC, and its, i.e. Mozambique's, I think, Paris Agreement commitments. So that's about Mozambique's position. Then it says, this aligns with the UK government's commitment to support developing countries to respond to the challenges and opportunities of climate change as part of its own Paris Agreement obligations. That's looking at a particular aspect of Article 2, isn't it? In the agreement.
Yes.
Yeah? And then it says the Paris Agreement also recognises global peaking of greenhouse gases will take longer for developing countries such as Mozambique, and that's Article 4.1. Project sits within Mozambique's longer-term climate change plans to establish strong social and economic stability. Now those statements seem to hang very specifically to those particular elements of the Paris Agreement, don't they? Rather than the temperature goals as such.
But it's all connected. That's
Well,
why I need to get on to
You say it's all connected, but when we actually analyse that paragraph, that's right, isn't it?
Well, what you get, if you get other bits of the climate change report as well. So, for example, because it's divided into Mozambique and international.
Yeah.
So there are two sections of it. If you go to page 299, it starts with the international impact. The bit before is the Mozambique impact. And then you get at 14, is it compatible? Which is the question that Mrs. Justice Thornton refers to.
At
And
14, what?
14, page 302, question 14. And what you get is a sort of, well, we will be submitting in relation to ground one, a sort of finger in the air analysis of what's going to happen to this gas, because there's no real calculation. This is where the fundamental errors were made, and that applies irrespective, obviously, of the legal error. And then you get an analysis going through the answer in 14, and you don't get an answer no.
No,
It's
well, you
not
get an
compatible.
answer exactly. I mean, that's precisely my point.
You get
Page 304 at the top, on balance, taking the three posited scenarios, it appears more likely than not. Over its operational life, the gas will at least replace some and or displace some more polluting fuels with the consequence of some net reduction in emissions.
exactly.
So it's saying, on balance, we think there'll be a net reduction.
Exactly.
But we're not sure, and we're still taking the decision, knowing that.
I think one also has to read the penultimate paragraph on 303, which is part of the same series of paragraphs in answer to question 14, which acknowledges in terms, doesn't it, that it is though recognised that investment in renewable energy offers by far a more environmentally sustainable pathway for the global community in meeting the requirements of the Paris Agreement. I mean, isn't that also part of the conclusion that's being expressed here?
It is.
I mean, do you criticise that?
Well, we do criticise it because it's not clear. Because there is no statement there that it is likely compatible or likely not compatible. We submit, indeed, that in fact, I take back, I didn't mean to, that wasn't actually what I meant to say. What I meant to say was that the on-balance conclusion at the end is the crucial bit, particularly when read in the light of the summary, because the minister, who was at that time Miss Truss, was pointed to read this document particularly, and will have read the summary.
Yeah, but just look at the last paragraph, that three-line paragraph beginning on balance, which I think is the one you wanted us to look at. Taking the three posited scenarios, so there were three possibilities considered, appears more likely than not, so that was a balanced view, was it, that over its operational life, the gas from the project will at least replace some and or displace some more polluting fuels with a consequence of some net reduction in emissions. I mean, that's classically an expression of balanced judgment, isn't it?
Well, we rely on the summary, and we rely on those parts in relation to Mozambique. And we also do not, as far as we understand it, it has not been said against us that in fact the ministers were informed that this may well not be compatible with the Paris Agreement.
You say in your skeleton argument that FOE doesn't criticise the Mozambicans, but surely the heart of your case is that they are doing the wrong thing, isn't it? That nobody has any business to be launching this kind of project at this stage, and they at least must be grossly in breach of the Paris Agreement.
Well, that is not a matter for us or this court. This court is concerned with not, well, it is indirectly the legality of the decision taken by the United Kingdom. And the United Kingdom has particular obligations in relation to the NDCs of developing countries. And they are particular obligations under the Paris Agreement. And those obligations are connected also with their obligations in relation to finance.
Yes. I appreciate that we're not seeking we are not hearing an application for judicial review of the policy of the government of Mozambique, of course not. But you're saying that the Paris Agreement may or may not allow the Mozambicans to do what they're doing, but that Article 2(1)(c) on its proper construction prohibits the UK from giving financial support to this kind of project.
Yes.
Doesn't it follow from that the Paris Agreement on its proper construction means the Mozambicans shouldn't be doing it either?
Well, it may well, but it's not something that we need to determine. We're concerned with the United Kingdom's obligations, ultimately here, not with Mozambique's obligations. As I said to you, and when I do get onto the Paris Agreement, I am getting anxious about time. I've already made the submission that what was landmark about Paris was that for the first time, both developing and developed countries were under the same commitments, albeit that there are differentiated responsibilities still in the agreement, while in the preceding Kyoto Agreement, it was only developed countries that had to make commitments to reduce emissions. It is a landmark change, and when one interprets the entire agreement together, as you must, the entirety of the agreement, you see that it involves the change of finance flows, but finance flows from the north to the south to assist them in what is ultimately an injustice. That's why I talked about the weighing up and trade-offs of injustices. It is ultimately an injustice that we have exploited our fossil fuels and grown wealthy, and Mozambique ultimately will not be able to, or Papua New Guinea or anywhere else which Total is extending its operations to. Because ultimately this is also a question of what corporates are doing. Those fossil fuels are being exploited globally for corporate profits, and these countries are getting a certain percentage. Well, that's how it works. They couldn't do it without that mechanism. But Paris provides for a realignment of finance and obligations on developed countries to send finance and technology to, and then there is a loss and damage provision to deal with this historic injustice.
Okay, let's get on to the Paris Agreement, because I think we need
Yeah, I am very worried about time, because I'm not even going to get onto ground one, I don't think. But in any event,
No, but I think we've covered a lot of the ground in the course of the interesting discussions we've had in this team.
so I'm going to start with the path to the Paris Agreement. It's the starting point is the science.
Sorry, is what?
The science.
Science.
Science. Science is the crucial and central starting point for all this. And while science played an important part in the UNFCCC, it became particularly significant for the negotiations for the Paris Agreement. The Intergovernmental Panel on Climate Change, the IPCC, was formed in 1988 by the World Meteorological Organization, endorsed by the UN, which is explained by Lord Justice Stuart-Smith at paragraph 26 of his judgment. It's made up of 195 governments which mandate it to assess climate change science. It doesn't undertake any research of its own, but collates and assesses scientific research of the entire global scientific community to provide the best scientific knowledge for decision making. And it produces comprehensive assessment reports every 6 to 7 years that are known as assessment reports, or ARs, and special reports, which are often requested by the Conference of Parties, the COP, of the UNFCCC or the Paris Agreement. And a crucial one of these reports is SR 1.5, which I'll take you to. The Conference of Parties, the COP, in adopting the Paris Agreement at COP21 in 2015, requested the IPCC to produce a report to assess the impacts of global warming of 1.5 degrees above pre-industrial levels and provided related GHG emission pathways. I'll take you to that decision. And it was on the basis of that report that the 1.5 degrees became an accepted temperature limit for the purposes of the Paris Agreement, namely the temperature above which there is a real risk of the most extreme events. Alok Sharma, quoting from this report at COP26, noted that at 1.5 degrees warming, 700 million people would be at risk of extreme heat waves. At 2 degrees, it would be 2 billion. At 1.5 degrees, 70% of the world's coral reefs die. At 2 degrees, they are all gone. And he says that is why countries on the front line of climate change fought so hard for the 1.5 degree temperature limit to be enshrined in the Paris Agreement. For them, 1.5 to stay alive, that was their slogan. It's not a hollow slogan, it is a matter of survival. And that, my lords, applies to Mozambique. The IPCC report concluded that on current trajectories, global warming is likely to hit 1.5 degrees between 2030 and 2052. And that's set out by Stuart-Smith at paragraph 27. So I'm going to turn first to the SR.
That's a big span, 2030 and 2062.
52.
Oh, 52. Still a big span.
Sooner than one might like.
No, but of course.
Applying a precautionary principle, 2030 is very close indeed.
Yeah. No, I'm just surprised at the 25-year gap, 25-year range.
Well, as I said, the IPCC takes all the science and it gives you the range. So SR 1.5, supplementary bundle tab 12, page 84. And then if we can read C1. So this is a 2018 report commissioned by the decision at COP that adopted the Paris Agreement. In model pathways with no or limited overshoot, 1.5 degrees global net anthropogenic CO2 emissions declined by about 45% from 2010 levels by 2030. So that's the drop one needs. Reaching net zero around 2050. For limiting global warming to below 2 degrees, emissions are projected to decline by about 25%. You saw how serious 2 degrees was as compared with 1.5. Non-CO2 emissions in pathways that limit global warming to 1.5 degrees show deep reductions that are similar to those pathways limiting warmer to 2 degrees. So one's got to include CO2, methane, and those other emissions. And then C1.3 sets out the remaining budgets that Mrs. Justice Thornton correctly quoted and relied on. So the centre of the paragraph, the associated remaining budget is being depleted by current emissions of 42 plus or minus 3 gigatons of CO2 per year, high confidence. The choice of the measure of global temperature affects the estimated remaining carbon budget. Using global mean surface air temperature, as in AR5, that's the report that preceded Paris, the IPCC report, gives an estimate of the remaining carbon budget of 580 for a 50% probability of limiting to 1.5 degrees, and 420, that's what she relied on in her calculations, for a 60% probability. And 420 is generally the figure that is used, because obviously one wants to be in a 60% probability range.
A gigaton is 1,000 tons, is it? Or a million?
It's 1,000 million tons.
A gigaton is 1,000 million tons.
Yes.
Good. Lost a few noughts, I'm afraid.
And this project, if one takes the figures of Bayes, the overnight back of the envelope figures, is 1.13. And then if we look at page 86, we see the pathways. And these are the pathways that Lord Justice Stewart didn't understand what was meant by the word pathways. Here they are. Now you see that various pathways, because this is a combination of science. So the IPCC has taken, I believe it was around 200 models, and it combines them. And these are various pathways. But what you will see, if you look at the first graph on the left, is that emissions globally, you draw a direct line down from where the thin blue lines, because they take four example pathways, which are in solid lines, 3 in blue and 1 in grey. You'll see that 3 blue lines involve reducing emissions starting in 2020. So that's when emissions need to start going down if the 1.5 degree temperature is going to be met. The grey line assumes an overshoot. That is, it assumes that temperatures will exceed and then go down again. And that is done through negative emission technology. The danger, of course, is one doesn't know what happens to things if, for example, the permafrost melts and the methane is released, whether in fact you can get back to the position previously. So you see those pathways, and if we then look at page 87, you see a more detailed explanation of those 4 exemplar pathways, and you see what needs to be done. And of course the coloured sections above the line 0 is the carbon budget. That's what's left. And we can't put any more than that up into the atmosphere. And again, if you draw a line down, you find that emissions need to start falling quite rapidly in 2020. And only in the last scenario, where you get an overshoot and then negative emissions technology, do you start descending at a later date. And then if we go to...
So you say that the words "a pathway towards low greenhouse gas emissions" in 2.1c refers to page 86 to 87 of the supplementary bundle in the IPCC report.
Yes. I say, no, perhaps that's the IPCC, this report was commissioned, or requested, I should say, by the COP in the decision by which they adopted the Paris Agreement. And I will take you to that. And these are the pathways that apply. They are not, they are projections based on other people's science that the IPCC, 195 governments, have brought together. It's a body of government experts appointed by governments. So then, if we go to C2, we see pathways limiting global warming to 1.5 degree with no or limited overshoot would require rapid and far-reaching transitions in energy, land, urban and infrastructure, including transport and buildings and industrial systems, high confidence. These system transitions are unprecedented in terms of scale, but not necessarily in terms of speed. and imply deep emissions reductions in all sectors, a wide portfolio of mitigation options, and significant upscaling of investments in those options. And the key point here is that, yes, this is an enormous transformation of our world and economy, unprecedented. But effectively, it is, in terms of speed, it is possible. And speed ultimately depends on finance. Now, if we then go to page 95, you'll see a summary. Perhaps you could just, no, just page 95. That summary, if my lords could read at some point, I'm going to press on, but I would just emphasise that the respondents are correct when they say that there is no single pathway. That is correct. There is no legally stated single pathway for 21C. What there is an amalgam of the entire scientific community brought together by experts appointed by 195 governments to come up with a range of pathways and what needs to be done. And it is by reference to that pathway and those budgets that the respondents should have assessed this project. So just the final paragraph. A world that is consistent with holding warming to 1.5 degrees would see greenhouse gas emissions rapidly decline in the coming decade. With strong international cooperation and scaling up of countries' combined ambition beyond current NDCs. In contrast, delayed action, limited international cooperation, and weak or fragmented policies that lead to stagnating or increasing greenhouse gas emissions would put the possibility of limiting global temperature rise to 1.5 degrees above pre-industrial levels out of reach. And that is why the government has aligned its public finance with the temperature goals, now applying those pathways. I'm now going to go to the emissions gap report, which you'll find in tab 21. Page 182. If I can take you to the introduction. This is the 10th edition.
Sorry, I missed the reference.
Page 182.
In
the
supplement.
emissions gap report. This is United Nations Environment Programme. Yes. So it's a UN body, also relevant to the UNFCCC and the Paris Agreement, and annually it produces an emissions gap and a production gap report to show the difference between what is being done, what is happening, and what needs to happen.
But this postdates the Paris Agreement.
This postdates the Paris Agreement. We've got this one because it's the one that would have been there at the time of the decision. So it comes every year, it comes in autumn. So this one would have been here in autumn 2019, and the decision was taken in June 2020. So it's the 10th edition. It provides the latest assessment of scientific studies on the current estimated future GHG emissions and compares these with the emission levels permissible for the world to progress on a least cost pathway to achieve the goals of the Paris Agreement. This difference between where we are likely to be and where we need to be has become known as the emissions gap. And then at the bottom right-hand corner of that page, greenhouse gases have risen at a rate of 1.5% per year in the last decade, stabilising only briefly 2 years, 2014-16. Total GHG emissions, including from land use changes, reached a record of 55.3 gigatons of CO2 in 2018. Fossil CO2 emissions from energy use and industry which dominate GHG emissions grew 2% in 2018, reaching a record of 37.5 gigatons per year. So we're still on an upward trajectory. And then the next page, there is no sign of GHG emissions peaking in the next few years. And you'll recall that it needs to peak in 2020 globally and then start falling. Every year of postponed peaking means that deeper and faster cuts will be required. By 2030, emissions would need to be 25% and 55% lower than in 2018 to put the world on the least cost pathway to limiting global warming to 2 and 1.5 degrees. And then page 186, paragraph 4, the emissions gap is large. In 2030, annual emissions need to be 15 gigatons of CO2 equivalent, lower than current unconditional NDCs imply for the 2-degree goal, and 32 degrees CO2 emission equivalent lower for the 1.5 degree. So there is a gap of 32 gigatons of CO2 per annum by 2030. Sorry, I didn't express that very well. What I wanted to say was that the commitments under the NDCs, if you just apply those, there is a gap of 30 gigatons per annum. So the NDCs alone will not cut it. And then the diagram on page 187 shows you, crucially, the major problem here. So you see the problem because you see that the line is going up. Current policy scenario, 2005 policy scenario, unconditional NDC scenario. So even with all the commitments complied with, you've got a problem because it's still going up, not very fast. But actually, the current policy scenario on the likelihood is really going up. And what we talked about at the beginning of this hearing, if you imagine the policy scenario of the line going up and somehow LNG lowers the line slightly, it has no impact for the purposes of the temperature goal. And that the respondents do accept. They accept that there is a net aggregate increase in global emissions, not that we are on a downward trajectory, but this will enable us to move down more quickly. They say this means that we will just be going up more slowly. So if the current line is like that on coal, we'll take you to evidence on that tomorrow, then actually LNG might possibly, they don't know, make it go lower, although it could equally displace renewables or pipeline gas or anything else and make it go higher. So if we look at the bullets below, with only current policies, GHG emissions are estimated to be 60 gigatons equivalent in 2030. It's the current policy scenario. On a least cost pathway towards the Paris Agreement in 2030, median estimates are 41 gigatons equivalent for 2 degrees and 35 gigatons for 1.8 and 25 gigatons for 1.5. So you get a gap there for 1.5 of 35 gigatons. If unconditional and conditional NDCs are fully implemented, global emissions are estimated to reduce by about 4 gigatons of CO2 equivalent and 6 gigatons of CO2 equivalent by 2030 compared with the current policy scenario. So these are just all the upward lines. The emissions gap between the estimated total global emissions by 2030 under the NDC scenario and the pathway limiting warming to below 2 and 1.5 is large. Full implementation is estimated to result in a gap of 15 gigatons, and the emissions gap for 1.5 will be 32 gigatons. If current unconditional NDCs, last paragraph, are fully implemented, there is a 66% chance that warming will be limited to 3.2 degrees. So if everything countries say they're going to do is done, temperatures will rise by 3.2 degrees. And I showed you what was said about 1.5. Now, 187 I was at. So paragraph 5, dramatic strengthening of NDCs is needed in 2020. Countries must increase their NDC ambitions threefold to achieve well below 2 degrees and fivefold to achieve 1.5. So this is effectively what Lord Justice Stuart-Smith is saying when he says, what's the point in all this? It's not going to work. And then we have the ratchet mechanism. But when he was interpreting the treaty, you'll recall that he said, I can't see how this can possibly happen because the gap is too big anyway. Then we have the ratchet mechanism, which is very important. The ratchet mechanism of the Paris Agreement foresees strengthening of NDCs every 5 years. Parties to the Paris Agreement identified 2020 as a critical next step in this process, inviting countries to communicate or update their NDCs by this time. Given the time lag between policy decisions and associated emission reductions, waiting until 2025 to strengthen NDCs will be too late to close the gap. And then the challenge is clear. The recent IPCC special reports clearly describe the dire consequences of inaction and are backed by record temperatures worldwide, along with enhanced extreme weather. Had serious climate action begun in 2010, the cuts required per year to meet the projected emissions levels for 2 degrees and 1.5 would only have been 0.7% and 3.3% per year on average. However, since this did not happen, the required cuts in emissions are now 2.7 per year from 2020. That's the global average. That's what's got to happen for the 2 degrees goal, and 7.6% per year on average globally for the 1.5 degree goal. Evidently, greater cuts will be required the longer that action is delayed. Further delaying the reductions needed to meet the goals would imply future emissions reductions and removal of CO2 from the atmosphere at such a magnitude that it would result in a serious deviation from the current available pathways. This, together with necessary adaptation actions, risks seriously damaging the global economy, undermining food security and biodiversity. Well, you heard what happens to coral in the earth, in the seas at 2 degrees and food security, but here we were talking about much more significant temperatures. And then if we go just to under paragraph 7, if the multiple co-benefits associated with closing the emissions gap are fully realised, the required transition will contribute in an essential way to achieving the United Nations 2030 agenda with its 17 sustainable development goals, which I will take you to in relation to the point about sustainable development and climate change being inherently connected, and the sustainable development goals refer specifically to the UNFCCC. And then take you to the production gap report, which is in tab, maybe it's back, tab 2020. And if you just look at the page 174, you'll see the key findings. Governments are planning to produce about 50% more fossil fuels by 2030 than would be consistent with a 2 degree pathway, and 120% more than would be consistent with a 1.5 degree pathway. So more than twice the production consistent with a 1.5 degree pathway. Several governments have already adopted policies to restrict fossil fuel production, providing momentum and important lessons for broader adoption. The global production gap is even larger than the already significant global emissions gap due to minimal policy attention on curbing fossil fuel production. International cooperation plays a central role in winding down fossil fuel production. And you'll recall me taking you to the point about US Exim funding this and saying that private finance was not available for this project because it was too high risk. One of the risks is, of course, stranded assets and lack of insurance. Because one of the dangers is that if you as a pension fund or an investment bank invest in fossil fuels and they are no longer able to be used, your asset becomes stranded and you have to declare that, and it is not insured. And therefore, it is governments that step in. And that happened in this project. Ultimately by US Exim at the time that the USA had left Paris and under Donald Trump. The continued expansion of fossil fuel production and the widening of the global production gap is underpinned by a combination of ambitious national plans, government subsidies to producers, and other forms of public finance. Public finance is a key problem that 21C is intended also to deal with. So if we then go to page 176, you'll see the points that I just summarised, or the report summarised on that page. Governments are planning to produce 50% more and 120% more. And then the analysis underneath, the analysis shows that in aggregate, countries' planned fossil fuel production by 2030 will lead to the emission of 39 billion tonnes, so gigatons, 39 gigatons of CO2 equivalent. That is 13 gigatons, or 53% more than would be consistent with a 2-degree pathway, and 21 gigatons more than would be consistent with a 1.5-degree pathway. This gap widens significantly by 2040. And by the way, does not include this project. And then on the right-hand column, oil and gas are also on track to exceed carbon budgets as countries continue to invest in fossil fuel infrastructure that locks in oil and gas use. The effects of this lock-in widen the production gap over time until countries are producing 43% more oil and 47% more gas by 2040 than consistent with a 2-degree pathway. And then under that, the global production gap is even larger than the emissions gap. Collectively, countries' planned fossil fuel production not only exceeds 1.5 and 2-degree pathways, it also surpasses production levels consistent with the implementation of the national climate policies and ambitions in countries' NDCs. As a consequence, the production gap is wider than the emissions gap. And that's significant because the United Kingdom, as I've said, has now put this into their NDC. But of course, you can completely undermine your NDC by doing something outside of it that counteracts all of its positive effects, which is what this project involved for the United Kingdom. Indeed, though many governments plan to decrease their emissions, they are signalling the opposite when it comes to fossil fuel production, with plans and projections for expansion. This hinders the collective ability of countries to meet global climate goals, and it further widens not just the production gap, but the emissions gap as well. So here, the United Kingdom committing to zero emissions can be wiped out effectively by financing production elsewhere. And then on the next page, 177, just to be clear, this report, it's the third paragraph down, reviews specific production plans, outlooks and support mechanisms in 10 key countries: China, US, Russia, India, Australia, Indonesia and Canada, and then Germany, Norway and the United Kingdom. It does not include Africa. And then in the bullet below that, many countries appear to be banking on export markets to justify major increases in production, while others are seeking to limit or largely end imports through scaled-up production. The net result could be significant overinvestment, increasing the risk of stranded assets, workers and communities, as well as locking in a higher emissions trajectory. That is, creating economies, for example in Mozambique, that become dependent on LNG, for example their power or their transport system becomes LNG dependent, and therefore this these emissions are locked in.
So, Ms. Samuel, I think we're running into the buffers of the day. You've made various indications that you're going a bit slowly. Are you going to be able to speed up?
I hope so. I would like to just finish my comments on this report, and that takes me to quite a good point today. So just the next page, the 2 paragraphs under fossil fuels at the heart of the climate challenge, we see again the numbers under last year, and then the following 2 paragraphs. So here we say, barring dramatic, unexpected advances in carbon capture and storage, these declines mean that most of the world's proven fossil fuel reserves must be left unburned. Ongoing expansion of fossil fuel infrastructure points in the opposite direction, however. Major infrastructure projects, coal, oil and gas, continue to attract investors, receive public permits, or otherwise government support. Energy analysts predict that investment in fossil fuel exploration, extraction and delivery infrastructure could remain at about US dollars $1 trillion annually until 2040. That is a good point to break, my lords. Tomorrow I'm going to deal with the UNFCCC and the actual specific interpretation of the terms of the Paris Agreement. I'm also going to have to get through the 2 legal arguments on grounds 1 and 3. If it is at all possible, I would ask that we would start at 10.
I don't think it is really possible to start at 10. You a lot of other things to do. What about you, David? Okay, well, we'll start at 10:15 and see how we go. But I mean, you will have to just tailor your submissions. You can give us bits to read instead of reading it all out. I mean, I know it has less impact, but we have got the message. You know, we do understand the serious factual position behind all this.
Just to finally to add, the reason I took you to that is to show that the position, the trajectory is up. So that is what the position is from the respondent's perspective as well.
Yeah, no, I mean, I see all that. We'll resume at 10:50.